then provides the code of ethics that are to be complied with. Now, as a professional, because you have told people out there that I hold this kind of qualification and I have these skills, people trust you, and you are therefore expected to exercise special knowledge and skill in providing the service. That is the same for lawyers, the same for accountants, the same for insurance brokers, and so on. It is expected that since we've told the public that we hold certain qualification and skills, they expect that we offer those services with special knowledge and skills. Now, ordinarily, professionals are expected to continually improve their professional knowledge through continuous professional education. Now, as I've already mentioned, you owe a duty of care, not just to your customers, but also to the public. Because somebody may not be your customer, but may seek your word on something. And once you give that, then you can be held against it. Now, generally, I've already touched on this. Professionals are defined by belonging to a professional body. For you, of course, is the Uganda Dental Association. You are licensed by a statutory body, in this case, the Uganda Medical and Dental Practitioners Registration Council. There is a law that governs your profession, and this applies to both professionals. In this case, the Medical and Dental Registration Act. There is a code of ethics normally that governs professionals. In your case, is the UMDC PC Code of Professional Ethics of 2013. And there's normally a disciplinary procedures in the event that you breach the code or the law. And I think this is something you all know. So it's just repetition of what you already know. Now, professionals are expected to exercise independence, honesty, and integrity and fairness in providing their services. Protection of your customers, in your case, is the patients. Respecting customers, patients, freedom of choice. In our case in Uganda, maybe sometimes customers may not have a lot of choice, but they have that right to move to the next professional if they are not satisfied with you. Competence of the professional, holding customer confidentiality. I think for you, this is for doctors and medical practitioners, this is very key. Patient confidentiality. Protection of customers' property. This may not necessarily apply to you, but it applies to other professionals. Now, that undertaking that you're going to provide professional service, you are meant to be fair, to charge a fair and equitable fees or remuneration. You don't overcharge customers because they lack understanding of the profession. And then avoiding conflict of interest. So those are some of the contents of most of the code of conduct or ethics that most professionals follow. Now, examples, of course, of professionals is medical practitioners, you people as dentists, architects, and designers, engineers, advocates, lawyers, financial consultants, insurance brokers, journalists, ICT consultants, surveyors, and valuers, and so on. There are many more. This is not exhaustive. So, obviously, we all know that dentists are professionals because your profession requires that you have special knowledge and skills, which you gain through training. You cannot practice without being registered by UMDPC. You subscribe to the code of conduct. In this case, your code of conduct, the code of conduct of 2013. You are regulated. I believe you are all expected to undertake continuous professional development. And for doctors, of course, you take the Hippocratic oath. And also common law governs you in terms of the duty of care. For you, there is the oath you take, there is common law which governs you, which is common law, the tort law, and also the statutory duty under the law, the statute. Now, I think that is knowledge that as professionals we all know. So that I want to go into the core of the presentation for today. Now, as all human beings, we owe duty of care to other people. Whenever you conduct yourself or you do something or fail to do something, you should be aware that you can cause either damage or injury to other people. That duty of care is governed by common law. And the duty of care is simply a moral or legal obligation to ensure the safety or well-being of other persons. And for you as medical dental practitioners, obviously this is a very, very critical duty to the patients. Now, all professionals owe this duty of care to those who buy your services or who depend on you for the professional expertise. A higher standard of care is expected of those who profess special training and skills. I've already mentioned this. Now, what happened, if you breach that duty of care, it can lead to either injury, including death, or damage to other people's property in the case of other professionals. And that can have very serious consequences. But before I move to that, you all know the oath you take. This is just a summary of it. Of course, there are various modifications that have occurred over the years in different countries. But the key thing about that oath is that you should never do harm. So as a professional, as a dentist, you are expected to act judiciously so as not to hurt or harm the patient. This forms part of the professional duty of care expected of health professionals. Now, the Uganda Law Reform Commission has been researching on the possibility of making insurance for health professionals mandatory. It's currently not mandatory in Uganda, but other countries it is mandatory. But that does not mean that if something went wrong, you will not be called upon to compensate. But these are quotations from their issues paper of 2017, in which they said in the medical world, patients consign their fate and life to doctors because they blind trust in the doctor's knowledge and skills. And as such, society entrusts the sacred duty of preserving the virtues of life and good health to the medical professionals. Hence, only the most qualified individuals should engage in this profession. Now, this emphasizes that duty of care. That report is available and you can go through it. We don't know when decision will be made to make insurance mandatory, but as I said, whether mandatory or not, I think it is an important consideration and we can look at it as we move along. Now, you handle human life. You can actually, as a doctor, you can save or end a life. But the intention is to save a life, not to end it. Society therefore expects health workers to carry out their duties with the highest degree of diligence, skill, and care. when a health professional acts negligently, it shocks society, which then expects the health professional to be sanctioned in one way or the other. A health professional does harm to a patient. A health professional who does, sorry, there's an error there, who does harm to a patient commits a medical negligence, which should lead to legal, moral, or criminal liability, depending on the circumstances. Now, case law has defined medical negligence as the omission to do something which a reasonable person will do, or doing something which a reasonable person will not do. So in either case, it's either you omit, you do something that you are not expected to do, or you omit to do something that you are expected to do. The Black's Law Dictionary defines as the failure to provide medical, dental, or psychiatric care that is necessary to prevent or to treat serious physical or emotional injury or illness. Now, medical negligence leads to legal, moral, or criminal liability, depending on the circumstances. I think this is a reputation. Now, what are the consequences of medical negligence? To the patient is that it can cause injury or death. That injury may be psychological or physical. It could be financial. Financial in the sense that that patient may end up spending a lot of more money to rectify or to remedy that injury, and therefore cause financial distress. And it can cause loss of trust to the medical profession, not only the profession, the one professional, but the profession, the whole profession. And what about to the doctor? One, it can lead to payment of damages in form of indemnification. Your license can be revoked. Your membership to the professional association can be revoked or suspended. There could be penalties, which would sometimes include exemplary and other penalties. It can lead to loss of your customers because they've lost trust in you. And in some cases, it can lead to jail term. And obviously, in almost all cases, it has reputational damage. In almost all cases, the moment that comes out, there is normally damage to your reputation as a medical practitioner. Now, those are just the basis of how this insurance came about, in that professionals are expected to act with due care, diligence, but then things can go wrong. However diligent you are, sometimes things do go wrong. An error can be committed, an omission can be committed, and that could lead to injury or even death. Now, the patient who suffers physical injury, emotional, or death, or the one who suffers death, the one who suffers injury can also ends up suffering some form of financial distress. Even the one who dies, the family or the dependents end up suffering financial distress. As I said, medical negligence can seek, the patient can seek compensation in form of both general and special damages. And the court, in its own discretion, can also apply exemplary, punitive, or punitive damages, or the patient or the claimant may seek that besides compensating them, you should be penalized as an example to others. Now, professional indemnity is meant to provide insurance coverage, the financial assistance or for compensation in the event that somebody claims that maybe you are treating some dental condition, and in the process, maybe you affected a nerve or something, and these persons, maybe the jaw, the nerves that control the jaw are damaged, and the person cannot even chew. And when it goes through either the court process or sometimes out of court negotiations, damages may be awarded, compensation may be awarded. That is basically what you're insuring. Now, insurance does not stop the error or omission from occurring. Insurance is a financial assistance in the event that happens, and then you have been asked to compensate. So a lot of talk sometimes in the general public is that if you can take insurance, but insurance can never stop a risk from occurring, an event from occurring. It is a financial assistance after the event. Now, it does not cover criminal liability, nor does it cover moral liability. Those are not the subject of insurance. Moral liability, of course, what you suffer is that reputation. Criminal liability, you could be fined by court or be jailed, depending on what is provided for in the law. Now, some of the examples of errors or negligence that have been subject to compensation, not necessarily in Uganda, include failure for you to exercise due diligence in handling the patient, in inquiring about the condition, failure to take necessary precautions as you treat the patient, misdiagnosing. This is a very common issue. Misdiagnosing diseases is a very, very common issue and has been subject to a lot of cases, I think including in Uganda. Offering wrong treatment or wrong prescription is another common cause of medical negligence. Ignorance towards the technical issues or protocols. Now, these are some areas where doctors who don't continuously improve their professional development, sometimes you end up using a procedure that is no longer in use, or giving medication that is no longer in use because you have not been keeping abreast of the developments in the field. Failure to comply or apply professional and medical standards of protocols, breach of privacy or confidentiality. The patient comes, gives you information about their health, and the next thing they're reading about it is either in social media or some newspaper reports about it, and then this is traceable to your office. Loss of patient documents, that can also be a cause of medical negligence, which can be, you can be asked to compensate the patient. There are more, of course, this is not exhaustive. Now, what does the insurance cover? The insurance covers general damages. These are the compensation that the court awards for the injury. Maybe somebody in the process of undergoing a medical procedure loses use of the jaw and sues, so the court will determine how much that person should be compensated. Now, an interesting argument sometimes that comes up is compensation for pain. Insurance generally doesn't pay for pain. In other words, somebody has suffered pain, but eventually recovers and is able to use the body part that was affected. Now, it's very difficult to determine the value of that pain. So that pain could be psychological or it could be physical. but insurance doesn't generally cover that unless the court is able to determine and include it in general damages. Now, special damages are, of course, the actual expenses incurred as a result of that error or omission. Treatment, subsequent treatment, transportation, and so on and so forth that the patient incurs, and is incurring this because an error or omission was committed, and therefore the patient had to go and seek further treatment, which may be more expensive. So these ones are normally proven by way of receipts and invoices and so on. Now, court, in its discretion, may also award the costs of the case or the suit. They may say, okay, besides this, you also pay both the cost of the claimant as well as your own costs. The cost of defending the case, in other words, you have operated somebody, the person has suffered injury, disability, the person takes you to court, you'll hire a lawyer to defend you. The cost of that lawyer would be included in the insurance. But also, if the costs are awarded against you, then both costs of the claimant as well as you as the defendant. Now, the cost of reproducing lost documents, that is also ordinarily covered by the policy. Now, defamation, these two are optional. You may choose to take them. They cost additional premium, but defamation, for instance, if somebody comes to your clinic and tells you of a medical condition, and the next thing you are discussing it somewhere where you're having a drink, and the information gets out, and the patient says, now this has damaged my reputation, and takes you to court. So these two are optional. The loss of patients, for you, you don't carry a lot of other people's documents. Lawyers do. Lawyers have wills, they have certificates of title and so on, which they keep for their customers, the clients. So if those documents are lost, so then the policy, if that lawyer has a policy, it will pay the cost of reproducing those documents or having them reissued. As I've already mentioned, it covers legal liability for negligence. It doesn't cover moral liability. It doesn't cover, that is liability at total liability. That is negligence, not criminal liability. It doesn't cover breach of contract, where you have entered a contract with somebody and you don't perform the contract, and the person sues you for non-performance of the contract. It doesn't cover reputational damage. Obviously, if you compensate the person, it may mitigate the reputational damage, but it doesn't cover that loss in terms of what you've lost in terms of your reputation. Pure financial loss or market or loss of market, where you've lost customers because there was negligence at your clinic, the policy will not pay you for that loss of goodwill or the market or customers. In other words, loss of expected income is not insured. Fines and penalties which are provided for in the law, the policy does not cover. The reason for this is that general insurance cannot be used to advance something that is an illegality. In other words, you cannot commit something and say, okay, my insurance will pay. So ordinary insurance doesn't pay fines, penalties, and punitive damages, which is what you pay and goes to the government. It doesn't go to the claimant. It doesn't cover amounts recoverable from other parties. This is, in insurance, we have what is called indemnity. In other words, you shouldn't make a gain out of insurance. You cannot, for example, have two policies and you claim from both. If you claim from both, they'll share that loss proportionately, such that what you get is what you are entitled to. Not that if you are the liability is 50 million and you have two policies, you've insured with each insurer 50 million, that you can claim from both 50-50, making it 100. If you do that, then each will only cover, because your loss was 50 million. So each insurer will pay 25 million to make 50. So you cannot gain. So in other words, if you claim from somebody else, for example, as a doctor, maybe you are operating on somebody. You have an anesthetist, you have other doctors and nurses involved. And it turns out that you are all sued, but the person who was negligent was maybe the anesthetist. Now, if your insurer, you will claim, your insurer will come in. If your insurer pays you, then they will seek compensation to recover from the person who was negligent. It doesn't cover anything to do with war or warlike activities, or nuclear or radioactive contamination. Now, nuclear radioactive contamination is interesting because most of the scans that we use today use radioactivity, but the levels are low, so those are not excluded unless there's something happens that there is excessive radioactive whatever contamination and affecting the customer. But the normal machines for scanning, the X-rays and so on, those are covered if the injury results from there. But in a situation where there is excessive radioactivity, for whatever reason, then the insurers may decline that claim. Work related to liability to your employees. In other words, if your employee is injured whilst performing their duties in your clinic, this policy does not cover that. The reason for this is that they are properly covered under the workers' compensation insurance, which is mandatory and which I believe for those who have clinics or who employ people, you should be having. It's mandatory under the law. So if you don't have it, you are breaching the Workers' Compensation Act. Gross negligence or deliberate disregard of duty of care. If this emerges that the injury or death occurs because you are grossly negligent or you deliberately disregarded certain procedures, the policy could decline that claim. Now, events occurring outside the country will not be covered unless you've sought extension of your policy to cover you when you are performing you're providing the services outside the country. So an important point here is that if you know that you provide services outside Uganda, then as you buy your insurance, you need to disclose that. You need to tell your insurer that I do my work in Uganda, I also do it in Kenya, I do it in Rwanda, so I would want to be covered whilst performing the duties in those countries. If you don't, the insurance just covers you for the services you provide in Uganda. Now, just a brief example of what happens in the region. In Kenya, the law is mandatory. I mean, the insurance is mandatory. The act reads, every practitioner shall in each year take a professional indemnity cover, and every health institution shall in each year insure the health institution against professional liability of its staff. So if you practice medicine or dentistry in Kenya, you cannot get a license unless you provide proof of this insurance. Now, there seems to be no other country in East Africa that has this as a mandatory requirement, but gradually this may come up. We've seen, for example, in our case, insurance brokers, a lot of things that are done eventually catch up, and it is introduced in Uganda. And reading, for example, when I was checking the budget yesterday, there's something the Uganda Insurance Regulatory Authority did a few months back. But when I check the Kenyan budget, I see them saying they're going to amend the law in a similar way. That is, requiring any foreign insurance broker to be regulated by the local regulator. That has not been there, but seems they are introducing it. So this may come in Uganda, but as I said, you do not have to wait for the law to come. This is something that as part of your duty, you need to consider. Because it doesn't remove the common law requirement. The patients can still sue you and the court can still award damages. Now, some of the cases, these are not necessary for dentists, but these are some of the cases where doctors or health institutions have been sued and the courts have awarded. Some of these possibly may have been reversed in higher courts, but as an example, there was a case of somebody called Helen Kimosho against Wakapita and Case Medical. This was in 2018. The court awarded 20 million plus interest at the 10% plus the cost of the case. The other one was Sarah Watemwa and Gosseltin. Now this involved this baby, and the case was against the Attorney General, in which the court awarded 500 million in general damages plus interest at costs plus the cost of the suit. The other one is another one called Capito Teleforas versus Attorney General again, and for Porto Hospital. This one, the court awarded 1.5 billion in general damages plus 16 million in special damages and the cost of the suit. You can see how this can go, the awards can go very high. The other one, Kasaira and 5 others, who were and the registers trustees of Nebi Catholic Diocese. This happened at a clinic which the Nebi Catholic Diocese runs. The court awarded 90 million in general damages plus 6.8 million in special damages. This was shared among all these 5 claimants, 6 actually. The other one was Munira Jivraj versus IHK and Dr. Edrisa Mwaka. The plaintiff sued IHK for reconstructive surgery gone wrong. The claim was 77 million. I couldn't get the ruling in this case. I guess possibly it's yet not yet concluded. It was a 2019 case. Now, as such, in the press, there are so many cases. Some of them end up at the council level, or some of them the patients end up abandoning. But there are a number of cases. We just Google medical negligence in Uganda. There are a number of cases that pop up, particularly in the press. As I said, some of them may not go to all the way to the to conclusion at the High Court or at End Court. So basically, that is a brief of what the policy covers and examples of where there have been cases of negligence. Now, if all those doctors and institutions had medical professional indemnity insurance, the insurers should have picked up the case and paid the compensation. I'm aware because in my previous working, I worked somewhere where we were handling for one of the hospitals. And I'm aware that there were quite a number of cases that came up. Some of them were paid, others were still going on. Because the policy does not pay until the damages are awarded. Now, why is that? Because you see, you cannot value human life. You as a dentist or lawyer cannot sit and say, okay, somebody's hand is worth this much. That is left to the court. And once the court awards, then that is the amount to be paid. So you cannot say, okay, oh, this person now can no longer use the hand, let me give them 5 million or 10 million or 100 million, because you cannot value it. So a lot of these cases wait until the court decides or some out-of-court negotiations are concluded. And just to digress, that is the biggest problem insurance has in terms of, for example, the motor third-party insurance. Insurers cannot, out of their own whatever, decide how much they are going to pay for the death of somebody. The matter sometimes ends up in court, and the court, once the court decides, then the insurers pay. Now, if the case delays in court, obviously people don't see the delay in court. They see the insurer who is refusing, quote unquote, refusing to pay the claim. But that's not the case. If the court decides, the insurers will pay. Except, of course, the small amount of 1 million, which is provided for in the law. But if somebody sued the driver, that will have to go to court, and court will have to decide before payment is made. Now, if you require this insurance, what do you need to do? The first thing is there is a proposal form that you need to complete. Basically, which some of the information the proposal form requires is for you to name the practice or the institution or your firm, provide details of the qualification and experience of the various practitioners or partners, if I may use the term, indicate what your average annual fees is, say for the last 2 to 3 years, details of any branches that you have and the practices there. Of course, for the branches, then you'll give details of the people running them. Past insurance, if you have had insurance in the past, you'll be required to indicate whether you have had insurance in the past. And then that question goes on to ask you whether you have had any claims in the past, whether any insurer has ever refused to insure you for any reason, or whether any insurer has ever imposed special requirements on your insurance because maybe the claims were too much. So all that is contained within the form. And when you are filling this form, if, for example, you went through a brokerage like ours, we come to guide you on the completion of the form so that you don't complete, it is sent and then comes back because maybe you have left some questions unanswered or the information in the form is not flowing or accurate. So when you are doing this, we can get somebody to come and sit with you and run through the form and provide details of any other information that may be required. Now, going to the end of the insurance process, because you take insurance so that insurance comes in when there's an event. What is normally required is that if an incident occurs that is likely to lead to a claim, not the term is likely to lead. So don't wait until you get a letter of demand for you to notify the insurer. If you are aware that an error has occurred, the best you do is report to the insurers that on this day, this event occurs, it may or may not lead to a claim. A lot of the liability claims, we have people reporting them when they actually receive a demand letter from a lawyer. Now, the problem with that is that you have not given the insurer enough time to go in and understand the case. So they get surprised. And because of this, they'll normally have a timeline within which you must report the incident. And that is contained in your policy. It's important that that is understood so that if there is an event and you report outside that timeline, the insurers would have a right to decline that claim. Provide details of the incident, including the names of witnesses, the people affected, witnesses, and so on. Submit all the claims. Now, the insurers will then tell you what will be required. Because these are liability, once you've done number 1 and 2 or bullet 1 and 2, the next one will wait until you get the demand letter or summons or whatever from the claimant. Now, when you receive those letters or summons, all you do is acknowledge receipt, but don't respond. You can say, you write back to the person who sent, say, we've received your letter, or the summons or normally would have somewhere where you sign. But the letter, you should just acknowledge receipt. You can tell them we've passed it to our insurers to handle. You give contacts of the insurer and they can pursue it with the insurer. But don't respond, because sometimes when you respond, then you prejudice your position as well as that of the insurer. It is important that the insurer understands the case and guides you on how to respond. But that does not mean that you shouldn't acknowledge or receive the letters. Submit the documents, because the insurers will then tell you what they need. Once they tell you we need 1, 2, 3, endeavor to get those documents and submit them quickly before the court case goes too far. Provide this information includes any results of any disciplinary procedures. If, for example, the council takes you through a disciplinary procedure, that information should be shared with the insurer. Whether the decision is negative or positive from your point of view, you should still inform the insurer, because the council's decision or any other mediation process may not necessarily be the final. The claimant can still pursue that matter to court. Now, you can appoint an advocate and inform the insurer. If you are not sure of which advocate to appoint, you can inform us and we'll discuss with the insurer and then guide you on who to appoint. Because insurers deal with these issues, so they know the insurers, the lawyers who are experienced in that field or in that area. Now, in terms of costing for this insurance, on average, it will be about 3% of the amount of insurance. If you take insurance, for example, for 150 million per year, it will be 4.5 million per year. This is not per month, this is per year. Of course, there are taxes and levies to be added there, but on average, that is the rate. That rate will depend on your experience and other factors. But generally in Uganda today, this is most likely the rate you'll get from every insurer. Now, in summary, therefore, why do you need this policy? You need this policy because it will protect you against legal liability due to negligence. And as they say, human beings make errors. However well you are trained, however diligent you may be, things can go wrong. And when things go wrong, then you need financial protection. Otherwise, you may be forced to close your practice or go into your resources to pay the claim and your other resources to pay the claimant. But if you have the insurance, then the insurance kicks in and compensates the claimant. Insurers will pay the defense costs, that's legal costs. It is in a way protects your estate, because in the absence of insurance, the claimants will come for whatever you own as a practitioner. As I said, it may not completely eliminate reputational damage, but the fact that you compensate the injured party kind of reduces the impact of that reputational damage. Now, the moral aspect of it or criminal consequences, sometimes it can be used as a mitigant to a criminal proceeding. And from a moral point of view, the fact that it was an error and you compensated somebody, then sometimes it could mitigate the liability. Obviously, going with that is that it enhances your image as a professional who adheres to professional ethics and the law. For example, if it is mandatory, as in the case is in Kenya. So this is insurance that as dentists or any other health professional you need, particularly if you are practicing independently. If you are operating within a medical institution, please check that they have medical insurance. I mean, this insurance, and that it extends to cover you as maybe a specialist. Because if their policy is not extended to cover you and you operate within their hospital and things go wrong, then you may be exposed unless you have your own insurance. So if you are an independent practicing specialist or dentist, you need this insurance. If you are practicing within a hospital environment and you are a resident, maybe dentist, you need to confirm that the hospital has this insurance. Now, those who operate within public or government hospitals, ordinarily it is the Attorney General, as you have seen, who is sued, and the Attorney General is meant to compensate the party. But if you are a consultant to Mulago, for example, you don't work there, but you consult as an independent practitioner, your insurance should be arranged such that it covers you even when you're operating or you are handling a patient at Mulago or any other public hospital. So that is all I have. I'll welcome any questions or comments. I hope I've shed some little light on this insurance. Insurance is fairly wide, so sometimes to know the extent to go into or not, sometimes a challenge, but I'll welcome any questions or any comments. Thank you.
Thank you so much, Mr. James Osum. Thank you so much for the presentation. Okay, now we have some questions in the chat section from Dr. Kwizera Godfrey.
Okay.
Can you see them?
Let me just check. Okay. Yeah, there is okay. I can see them. Does professional indemnity insurance apply to only private facilities, individuals, or stroke NGOs? Then the other one is, how about Workmen's Compensation Act? Does it apply to only government health facilities? Now, the first one is that professional indemnity covers you as a professional. If you work within a hospital or maybe a mission hospital, then the hospital may have insurance. If you are employed there, then it's a hospital that is supposed to have that insurance. So the hospital can actually buy this insurance. And some of these private hospitals actually have insurance that covers the hospital, and that then covers anything that goes on within the hospital, except where you are operating as a specialist consultant, which means you are responsible, you are paid your fees separately, and so on. In that case, then your insurance where you operate is what will cover you. But you need to make sure that the insurance is extended to cover you while operating as a consultant outside your clinic, if I may use the term. Now, in terms of workman's compensation is for anybody who employs people. What a lot of people don't know is that even your house girl or garden boy can actually sue you, and you'll be required to compensate. And not even suing, they just need to go to the Ministry of Labor and report you. So anybody who employs people for what in law is called the contract of service, where you've employed people, whether they are working temporarily or permanently, you are required by law to take that insurance. This compensation is not to your patient, it is to your staff if they get injured while working. If an example is you are a doctor, you are employed in Mulago, you earn salary, and in the process of maybe treating a patient, particularly in a case like when there is an infectious disease and an error occurs and you get infected, in the process of treating a patient, you can actually make a claim against the employer. And if the employer has insurance, then the insurance will pick up that claim. We in my experience, we've had cases where doctors have made a claim because in the process of treating an HIV positive patient, they end up getting maybe pricked and they get infected. We've had cases where a doctor or a nurse has made a claim that they suffered an infection in the process of providing service within a hospital environment, and they were employees of that hospital. So this covers employees, it doesn't cover the patient. I hope I'm clear. Is that okay?
That's fine. I'm satisfied.
Okay, thank you.
Thank you.
Okay, thank you, Mr. James. Still, there is
just a moment. I think there's another question from Peter.
From Dr. Peter Rokunsuga, yes.
Yes.
He's asking.
Yeah.
We as surgeons.
Yeah.
We as surgeons usually ask our clients or patients to sign a consent form before any surgical procedure. Does this consent form offer any protection to us, or we are always legally liable?
Okay, in law, there is something that can be used as a defense. A defense does not protect you 100%. And an illustration is, you've seen these signs of vehicles parked at owner's risk. I sometimes wonder whether the word owners means the owner of the vehicle or the owner of the premises, but that sign can be used as a defense, but it doesn't protect you 100%. So the consent form may not protect you 100%. In other words, the patient has signed the consent form. As a professional, you are expected to undertake that surgery using certain protocols with due care, but something goes wrong in the process of the surgery. You make an error. The consent form will not protect you. It can be used as a defense, but it cannot protect you in the event somebody sues and it is proven that you acted negligently. So the form is a defense, but not necessarily a full defense. I mean a protection. I hope that's clear.
Yes, it's very clear.
Okay, thank you.
So doctors with any questions, please. Otherwise, if there are no more questions, let me give this opportunity to the President, Uganda Dental Association, to say something and conclude. Doctor,
Thank you.
Dr. Batalingaya. I think the president is not there, or I don't know. So let me take this opportunity to thank you very much.
This is Dr. Yagnik. I'm the Vice President of Uganda
Mr.
Dental
Vice President,
Association.
welcome.
And I would really like to thank you, Mr. James Omoro, for a fantastic brief on our liabilities and indemnity. Thank you, and good night, everybody.
Night. Thank you very much for the attendance. Thank you very much, the presenter. Thank you very much. Have a good evening.
Thank you so much. We will share this presentation and our contacts are there. So in case you need to get more information or you understand this more, you can get in touch with us. We will share the presentation.
James,
Thank you.
Sorry, James.
Yeah.
Any questions?
There's a last question on what should be ideal coverage limit.
Okay.
What should? Oh, okay. I can quickly answer that. Yeah. Now, on what is normally called liability insurance, there is no scientific formula for determining how much you should insure. The guidance should be, one, how active is your clinic? What kind of people visit? If, for example, you see very affluent, the high end of the rich people, then it means the claim you are likely to face is going to be high. And also now, what can you afford? Because you may choose a very high limit whose premium you may not be able to pay. So there's no scientific formula for determining how much you're going to insure. And this does not just apply on this policy alone. It applies on all liability policies, because in law they call them, these are cases where the value of the amount to be compensated cannot be determined in advance. So it's hard to tell you that this is the limit to take, but you need to look at the activity of your clinic, the kind of patients you see, what are your fees like, and so on. So you can start small. As your clinic grows, then you keep increasing. Thank you.
Thank you very much. There is a hand up. Dr. Okonsuboga, do you have any question? If you have any question, please, you can ask. Your hand was...
Let me ask a question in the meantime. I was wondering, suppose many dentists are employed in one clinic. Is it better to take a coverage for the whole clinic or individually as separate doctors or dentists operating within that clinic? Can you give us a small rundown on that? We would really appreciate it.
Yeah, normally this policy has, okay, if I may call it, the two amounts that you insure. One is an amount for any one event. In other words, if there was one negligence, how much is the insurer going to pay? And then you can have an aggregate. If you were to have 2-3 cases in a year, how much will the insurers pay? But as a single clinic, you don't have to take individual policies. You take a policy for the institution. And within that institution, then there'll be a limit for any one claim and an aggregate if there were more than one claim.
Thank you very much.
I hope that's clear.
Very clear. Thank you very much.
Thanks again, Mr. James. Thank you very much for the presentation.
You're welcome.
Good night, everyone.
Thank you and good night to you too.